This is Barry Zalma on insurance. Today it's time to speak about the doctrine of Uberrimae Fidei, or in English, utmost good faith. Insurance is a business that requires that the parties to the contract of insurance act ethically and with utmost good faith. Ethics is a process of systematically applying, using, defending, and recommending concepts of right and wrong behavior. Ethical behavior is always required of both parties to a contract of insurance for the system of insurance to work. If any party to the insurance contract acts unethically, the ability of insurance to work effectively, to provide the indemnity promised by the policies, and to be profitable will fail. Ethics is, therefore, the essence of insurance. Since insurance was first created back in ancient Sumeria alongside the Tigris and Euphrates rivers, it has been a business of utmost good faith. As a result, the insured and the insurer are expected to treat each other ethically. Insurance was created to spread the risk from individuals to multitudes. Spreading the risk in a fair, ethical, and honorable manner from one person to many is the basis upon which a system of insurance was founded. The insurance contract, since modern insurance was first created, was founded on the concept of Uberrimae Fidei. The Latin phrase Uberrimae Fidei is used to express the principle that a contract of insurance must be made in perfect good faith, with neither the insurer nor the insured concealing anything from the other. In the case of insurance, both the insured and the insurer must observe the most perfect good faith towards each other, so that the insurer understands the risk it is asked to take, and the insured understands the risks accepted by the insurer. Insurers and reinsurers, those who insure the insurer, are dependent on utmost good faith, which may be viewed as a legal rule, but also as a tradition honored by insurers and ceding insurers and reinsurers in their ongoing commercial relationships. Uberrimae Fidei has its roots in British jurisprudence. The doctrine has historically been applied to all insurance contracts issued in or to be performed in the United States. The doctrine of utmost good faith was stated by the U.S. Supreme Court dating back to 1828 in a case called McClanahan v. Universal Insurance. Several federal cases have applied the duty of Uberrimae Fidei in the marine insurance setting, applying the doctrine more strictly than in property, casualty, life, health, or disability insurance. Under marine insurance, that's insurance of vessels going across wide spans of water like the oceans and the Great Lakes. Under marine insurance's interpretation of Uberrimae Fidei, any failure to disclose a material fact not known by the underwriter that is or should be within the knowledge of the insured party is grounds for rescission of the policy, even if the omission or misstatement is the result of the insured's mistake, an accident, the insured's forgetfulness, any of those grounds, if it deceives the insurer, is grounds for rescission. In the marine setting, the insured is required to disclose everything that is material to the insurer, even if the insurer does not ask. Not all federal circuit courts apply the Uberrimae Fidei doctrine to marine insurance policies, but most do. The doctrine of Uberrimae Fidei, the highest degree of good faith, provides that failure by the insured to disclose conditions affecting the risk, of which he is aware, makes the contract voidable at the insurer's option. Insurance policies, traditionally contracts Uberrimae Fidei, and a failure by the insured to disclose conditions affecting the risk of which he is aware, makes the contract voidable at the option of the insurer. Similarly, misrepresentation or concealment of material fact by the insurer allows the insured to declare the contract void at the insured's option. That is because the duty to treat each other fairly and in good faith is mutual. The majority of courts, faced with the application of Uberrimae Fidei to a marine insurance policy, have found that utmost good faith applies. Insurance cannot operate. It cannot exist profitably or even to work at all without the ethical doctrine of Uberrimae Fidei. Under the doctrine of Uberrimae Fidei, or utmost good faith, the insured in a maritime insurance contract is required to disclose to the insurer all known circumstances that materially affect the insurer's risk, the default of which renders the insurance contract voidable. The parties to a marine insurance policy must accord each other the highest degree of good faith. This duty of good faith requires the insured to disclose to the insurer all known circumstances that materially affect the risk being insured. Because the insured is in the best position to know of any facts that may be material to the risk, the insured is obligated by the doctrine of good faith to disclose those facts to the insurer, regardless of whether the insurer makes a specific inquiry about the facts. For example, if the owner of a vessel knows that its captain is an alcoholic who may be drunk at any time when the ship is being set upon the sea, must disclose that fact to the insurer, and if it isn't disclosed, the insurer can void the policy. Similarly, if the ship has a bilge pump that doesn't work and is taking in water, and that fact is not disclosed to the insurer, the insured has breached Uberrimae Fidei, and the insurer can declare the policy void. The doctrine reflects an enlightened moral policy based on the presumption that the party procuring insurance is not in possession of any facts material to the risk which he does not disclose. Indeed, it is the duty of the insured to place the underwriter in the same situation as himself. An insured who conceals or misrepresents a material fact commits fraud, which avoids the policy and is a clear breach of the ethical obligation of the insured. Fraud is an obvious breach of the contract and the implied covenant of good faith and fair dealing, because a material misrepresentation made with knowledge, provided to an insurer with an intent to deceive the insurer, that effectively deceives the insurer to its detriment, is fraud under common law understanding of what fraud is. It is the ethical obligation of the insured to truthfully and fully advise the insurer of the risks the insured is asking the insurer to take. Failure to do so, even if there was no intent to deceive, is sufficient to allow the insurer to rescind the policy if the insurer was actually deceived. In some instances, the law chokes on the issue of ethics and good faith. It is sometimes difficult for a court to determine which of the two considerations influences the classification of insurance contracts. At least the insurance considerations have been referred to as Uberrimae Fidei in England and in the United States. The two countries, however, are not necessarily in accord in their interpretation of Uberrimae Fidei. Nothing is better established in the law of marine insurance than a mistake or commission material to a marine risk, whether it be willful or accidental, or result from mistake, negligence, or voluntary ignorance, avoids the policy. Concealment in the law of marine insurance is the failure to disclose any material fact or circumstance in relation to the subject matter of the contract which may increase the liability to loss or affect the risk or obligation assumed, and which is in fact or law within, or ought to be, within the knowledge of one party, and of which the other party had no actual or presumptive knowledge. In the case of marine insurance, the insured must disclose all facts material to the risk, and in default of such duty the contract may be avoided by the insurer. The policy never attaches to the risk and is void for the reason that the risk assumed is not the one intended to be assumed by the parties. This was Quintero versus Geico Marine, a 2019 decision of the Third Circuit Court of Appeal. In the leading English case of Carter versus Beam, decided in the House of Lords in 1766, Lord Mansfield declared that even an innocent concealment of a material fact made the contract voidable, saying that the question, therefore, must always be whether there was, under all circumstances at the time the policy was underwritten, a fair representation or a concealment, fraudulent if designed, or though not designed, varying materially the object of the policy and changing the risk understood to be run. The doctrine of Uberrimae Fidei obligates the assured to volunteer information which might have a bearing on the scope of the risk assumed, and the failure to do so will allow the insurer to avoid the policy. This video was adapted from my book, Ethics for the Insurance Professional, 2nd edition, which is available as both a Kindle book and a paperback from Amazon.com. If you found this video to be interesting or useful to you and your colleagues, please pass it on. It's free. And please also subscribe to my Rumble channel and click on the Rumble button if you think the video was worth your effort. My YouTube channel, my blog, and my Substack publications so that you can be advised of future videos and future blog postings. Thank you for your attention.